Hello, and welcome to a very special fifth and final installment of the Symposium on Federal Agency Adjudication, co-sponsored by the Administrative Conference of the United States, ACUS for short, George Mason's C. Boyden Gray Center for the Study of the Administrative State, and the Center for Progressive Reform. My name is Jeremy Graboyes. I serve as a Deputy Research Director with ACUS, and joining me as moderator today is the Gray Center's Executive Director, Adam White. The symposium's first four panels explored issues related to the appointment and removal of adjudicators, the management side of adjudication programs, procedural reform efforts, and alternatives to traditional agency adjudication. Recordings of all four panels are available on ACUS's website at www.acus.gov/adjudication-symposium. We're pleased to conclude the series today with three of the foremost scholars of administrative law. And I mean that quite literally, they've written the books on the subject. Returning from the symposium's first panel is Professor Richard Pierce. Professor Pierce is the Lyle T. Alverson Professor of Law at the George Washington University. He's also a member scholar with the Center for Progressive Reform, a member of the Gray Center's Advisory Council, and a senior fellow with ACUS. Professor Jeffrey Lubbers is a professor of practice in administrative law at American University's Washington College of Law. Professor Lubbers is also a special counsel with ACUS and from 1982 until 1995 served as its research director. Last but not least, Professor Michael Asimow is the Dean's Executive Professor of Law at Santa Clara Law School. Professor Asimow has a long history working with ACUS. Most recently, he is the author of Federal Administrative Adjudication outside the Administrative Procedure Act, which is available on ACUS's website. Professor Asimow is currently studying the role and responsibilities of agency heads in agencies that perform both enforcement and adjudicatory functions. We look forward to that report. Thank you all for joining us today for what I know will be a fascinating discussion of federal agency adjudication. And without further ado, I'll hand things over to my co-moderator. Adam?
Thanks, Jeremy, and thanks everybody for tuning into this conversation. It's been such a pleasure to get to help organize these, the last four discussions and now this one. You know, I feel like we've covered just about everything in adjudication, big picture and small picture, but maybe let's start with the biggest question of all. All three of you are experts in adjudication, but also in administration and administrative law in general. So with that in mind, how should we think of adjudication's role? What's its proper place in modern administration? And why is adjudication seem to be increasingly the subject of debate, sometimes controversy in the debates surrounding administrative law? I don't know who would like to take that first. Maybe Professor Lubbers?
I'm not sure why it's becoming more controversial these days, but when the APA was drafted, adjudication and rulemaking were the two principal types of procedures that agencies were supposed to use in carrying out their functions. And so, you know, when we all teach administrative law, we say that anything that an agency is doing is categorized as rulemaking or adjudication. The APA was being drafted, adjudication was the main issue of contention. There was a lot of concern that in the New Deal era, that these agencies were being given functions to adjudicate that should have been reserved for the federal courts. And there was a lot of that's what most of the debates leading up to the APA were all about. Rulemaking was almost a sidelight at that point. Only around 1970, when a lot of rulemaking statutes were passed and lots of important regulations started being issued, did rulemaking become quite politically salient, and presidents decided they needed to get control of it, and executive orders were issued on rulemaking. And then adjudication kind of became the forgotten area of administrative law. Maybe it's coming back because we've kind of exhausted ourselves on rulemaking. And since agencies do make policy through adjudication and have always had the ability to do so, there's starting to be some concern about how agencies are doing that. Rulemaking is thought of as rather more difficult than it used to be. It's time consuming, so maybe agencies are starting to make more policy through adjudication than they used to. And I think the Supreme Court has started to issue some rather formalistic decisions that have called into question the status, selection, and removability of ALJs, administrative law judges. And so all that has brought it to the fore. And now we have a situation where OMB is issuing directives and presidents issuing executive orders concerning administrative adjudication.
I agree with everything.
Pierce, or go ahead, Professor Pierce.
I agree with everything Jeff said. I just add a few other things. First of all, I divide agency adjudication into three categories, and starting with the adjudications that are conducted by regulatory agencies. And that's where I think there's been a lot of controversy lately with, there's certainly people who, and this is a long-standing gripe about adjudication, people who believe that agency adjudication in regulatory cases is biased against the regulated firm and for the regulatory agency, and they would prefer to have all the cases resolved in federal courts. I think also there's an opportunism involved there. I've talked to a number of lawyers where I've asked them, why are you bringing this case? And of course, the answer from any good lawyer who's serving his client is because my client got a horrendous penalty, and I'll do anything within the boundaries of law to get rid of it. And so, I don't know where I am on the philosophical debates and constitutional debates, but I sure know what's in my client's best interest. That would be to get this fine vacated, this penalty vacated, and then hope for a better result in the next case. So some of it is opportunistic, some of it is the principled objection based on perception of bias. Then the next category are the benefit cases, often referred to also as the mass justice cases, and they raise terribly important issues, really intractable issues of how in the world do you manage an adjudicatory regime where there's somewhere between 500,000 and 1.5 million cases per year. I don't think they raise the same level of controversy on ideological grounds or on concerns of bias. It's much more a practical matter of how in the world do you manage those systems. And then the third one I'd name is immigration, which I think is one of a kind, where the stakes are extraordinarily high and where it has always, from the beginning of the nation, been the subject of a whole lot of controversy, and it's even more controversy today.
So I'd like to do tackle a different way of classifying adjudication than Dick Pierce did. So as we all know, the Administrative Procedure Act is extremely defective in its treatment of adjudication because it only covers a sliver of federal administrative adjudication. It covers all rulemaking, but not all adjudication. Vast segments of federal administrative adjudication are left out of the APA. Immigration, veterans appeals, patent and trademark appeals, EEOC, and many, many others are not governed by the APA at all. The hearing officers or presiding officers who decide their cases are not ALJs and aren't given the same protections of their independence as the ALJs. So in my mind, it's these non-APA agencies where the real problems exist. And it's really important that we not limit our discussion just to the APA, but instead look at the others. So in Administrative Conference Recommendation 2016-4, for which I was the consultant, I broke down federal adjudication into types A, B, and C. Type A is the APA, but type B are all the other evidentiary hearings not covered by the APA. And our reform focus, I believe, should be on those, especially the independence of the presiding officers in those cases. Type C are the vast number of adjudications where there is no evidentiary hearing. And it's even more elusive to try to prescribe procedural fairness for those.
Now, let me just add, in addition to the report that Michael wrote, or the book, the source book on adjudication, the report he's referring to is titled Evidentiary Hearings Outside of the Administrative Procedure Act. And of course, it's available on ACUS's website in conjunction with those recommendations. Jeremy, why don't you ask the next question?
Sure, that actually leads in quite nicely. We've talked about the sort of politicization of adjudication. We often think of agency heads as the most political figures in an agency, for good reason. They're appointed by the president. What is or should be the role of agency heads in adjudication, and what place is there for adjudicators' independence from agency heads, which I guess also begs the question of what is independence?
Well, if I can jump in on that one with my own slant, it's work that I'm currently doing for ACUS concerns the charging decision. I think that's really the most important decision in the whole case, is the decision to charge, to issue a complaint. Because at that point, the target basically has to either settle the case, perhaps on very undesirable terms, or gear up for a long, arduous, expensive adjudicatory process. So it's very important to think about this charging decision. And of course, we know that many agencies, most of them really, independent ones particularly, both investigate and prosecute and adjudicate. And there's a big issue about the agency heads. The most important check and balance on prosecutors in this case is that they can't just prosecute the case. They must get the approval of the agency heads. And so there's a meeting between the prosecutors and the agency heads to decide whether this is an appropriate case to issue a complaint. And there's quite a bit of controversy surrounding this because, of course, the agency heads both make the decision to prosecute. And then a couple years later, after the administrative judge decides the case, they make the final decision. I think this combination of functions is essential, and that agency heads should control the charging decision. But not everyone agrees with me about that.
Well, my starting point would be the Administrative Procedure Act. The big complaint, persistent complaint, and pretty well supported complaint throughout the 30s was that what were then called hearing examiners, now ALJs, were biased in favor of agencies. And what the drafters of the APA did was, with respect to formal adjudication, at least coming back to Michael's point, with respect to formal adjudication, they identified the 6 different ways in which an agency that clearly has a bias in favor of its own views in a regulatory adjudication might apply pressure on an ALJ to get them to decide the case and to make all the evidentiary rulings in favor of the agency. And they came up with a statutory provision to prohibit all pressure from the agency in each of those areas. And I think that's about as good a job as you can do in terms of conferring decisional independence on agency adjudicators. And of course, back to Michael's point, the vast majority of adjudications are not governed by those provisions of the APA or by any provisions for that matter. And hence, those adjudicatory officers have no real insulation from potential pressure from the political heads of the agencies to decide cases their way and make evidentiary rulings their way.
And the Supreme Court has upheld the situation of having the Federal Trade Commission launch the complaint and then decide the case at the end in the Cement Institute case, and with Roe versus Larkin, they upheld, the state board doing the same thing. So it's not necessarily a violation of due process for that to happen. And so with the separation of functions provision in section 554D of the APA, I think is generally thought of as fair process for those cases that are formal adjudications. The other non-APA adjudications that Michael spoke of are not governed by 554D, so they're only governed by due process, and in terms of this issue. And so, the party would have to show prejudice because of some internal communication. But going back to the need for independence, I mean, the main need for independence is for the administrative law judge. And that's what was guaranteed in the APA through those provisions that were in Section 11 and now at the end of Title V. And those are the provisions now that are coming under some question, whether or not, President Trump changed through executive order, changed the selection process to get away from what was supposed to be a merit selection process. And his Justice Department has been litigating the issue of whether or not the removal provisions, for-cause removal provisions that protect administrative law judges from removal, except for cause, whether that's unconstitutional. I'm sure we'll get into that in a few minutes.
Yeah, thank you. I'd like to follow up because, oftentimes we think of the relationship between the agency head and the adjudicator as the relationship in a specific case, but stepping back more broadly, we also have a sort of employee-employer relationship. We've touched on the idea in earlier panels of the agency head as the individual who appoints and removes adjudicators across a program, establishes quality control structures or delegates the authority to maintain quality control, decide appeals or delegate, as in the case of, for example, USDA, the authority to hear appeals, establishes or delegates the establishment of procedural and evidentiary rules. We've sort of touched on adjudication as a mechanism for policymaking, which maybe flows directly to the agency head, maybe not. So what does it mean in that case for an agency head to be impartial? And perhaps what is the proper place of an agency head as the top of an adjudication system, not just a single adjudication?
I think that's really tough, at least in the context of regulatory adjudication. It's really tough. I think it's pretty easy for the head of Social Security to honestly stand up before any audience and say, what I want to do is get the decisions right. But the heads of regulatory agencies, they got there because they got a particular set of views and an agenda, and they want to accomplish that agenda through every means possible, and that includes, in many cases, adjudications. And so I think it is unrealistic ever to expect the head of a regulatory agency to be impartial. Not in the sense, I mean, you certainly can disqualify the head of an agency if I don't know if it's his brother-in-law or somebody he hates, or some source where he's got money at stake. In the case, there's elaborate statutes and rules that are the basis for disqualification in those circumstances. But when it comes to point of view, the agency head is almost always going to be biased, and that presents some problems of the type that Michael described, but we can't change it, and I don't think we should change it.
And when I talk to foreign visitors in our adjudication system, once I finish describing it, they'll say, you invest so much time and energy in making your administrative law judges independent, and then you let a political appointee turn their decision. Why do you do that? Well, that's the system we have. And there are some limits on the agency head's ability to overturn, but the APA makes it pretty clear that they have broad discretion to do so, especially with questions of law questions of policy, and even to some extent, some disagreements on the fact finding. The only real limitation is if the fact finding by the ALJ was based on credibility determinations, especially demeanor evidence, then the courts are not going to let the agency head overturn the ALJ because the ALJ was the one that saw the witnesses. But otherwise, they have a lot of authority, and it's because of accountability. They're the politically accountable official. And, you know, there's judicial review. Universal camera case in 1950, 51 said that the courts review based on the whole record. And that means the courts have to look at the ALJ's decision as well as the agency head's decision if there's a disagreement. And so if there is a disagreement, the courts are going to look at it more closely. So that's elevated the importance of the ALJ's decision.
I wanted to add that there's an additional protection here that we shouldn't forget, and that is the requirement of partisan balancing in the appointment of agency heads. In most of the regulatory agencies, they're multi-headed, and there's a requirement of partisan balance between the political parties. And I think that's great. As long as the agency heads are allowed to have uninhibited discussions. They are making policy, as we all know. That's very helpful to have a diversity of views at the agency head level. A big problem with that is federal sunshine laws that really inhibit this kind of discussion in private. It has to be public. People are afraid to really say what they think when the media is watching.
What about the executive agencies that have administrative law judges? The purely executive agencies, the cabinet departments, and so on.
Right. So they're generally only single-headed, and you don't have this diversity of views. It's a strength, though, of the independent agencies that, perhaps with the exception of the Consumer Finance Protection Bureau, they are multi-headed. I think it's a strength, and it does apply to these important independent enforcement / adjudication agencies.
It's interesting when you look at the case law, and I write a treatise. I'm stuck reading every opinion, no matter how boring it might be in the field. And what I detect over time is that the effect of an administrative law judge's decision that is different from the agency's ultimate decision is, I think, virtually identical to the effect of a dissenting opinion in the context of one of these multi-member agencies, that each of them serve to alert the judges who are engaged in the review process that there's some serious disagreement among some serious people. Let's take a really close look at it. And empirically, we know that either when there's a dissent in the context of a multi-member agency, or when there's a contrary ALJ decision, the rate of upholding the ultimate agency decision goes down quite a bit.
Also, I think Jeremy's question was most pointedly discussed in the previous sessions, which I recommend to everybody, by the way, during the discussion of the immigration adjudication system, which is not an APA adjudication system, but it's almost as formal. But you know, there you have this Board of Immigration Appeals, but then you have the Attorney General who is over that and can decide whether to hear a case. And lately, the Attorney General has been very aggressive in doing that, and even reopening old cases under that certification authority. So that's a clear example of you know, a single-headed person, a single-headed agency, the Department of Justice, exercising policy control over an adjudication system.
Professor Lubbers mentioned the removal issue. Maybe we'll just stay on that for a moment while we're talking about agency leadership. Obviously, that's the thing that folks are focused on now that Lucia has been decided. I'd be curious to hear your thoughts on both where these debates stand and how you think they might shake out, if you want to put your prediction hat on. And I just, one little note before you answer. In the brand new issue of the Journal of Supreme Court History, there's this fascinating article by Robert Post about the Myers case and how Chief Justice Taft went about writing the Myers decision. And going back and rereading the article and thinking about it, and thinking about these removal issues, I'm reminded that even in that Myers decision, the high watermark of executive removal power, Chief Justice Taft even acknowledges at the end that there are some officers with quasi-judicial duties, and it might raise due process issues if the president were to fire one of those officers during one of those proceedings. But then he distinguishes it from, well, maybe the president would have to just wait until afterwards and remove somebody. Sort of bifurcates the removal question, sort of the heat of the moment versus after the fact. I don't know if that distinction means anything anymore in the case law. I don't know if it means, if you have any thoughts on that, but I'd just be curious to hear your thoughts in general on these ongoing removal debates.
On the prediction side, I make it about 50-50 as to whether the Supreme Court's going to apply the free enterprise holding to as the basis to say that ALJs, the statutory protections against removal of ALJs are unconstitutional. On the merits and more broadly, we really are talking about real tension between Article 2 values and due process values. That makes all of these questions quite difficult. And I actually have gone back and reread the 91 pages that Chief Justice Taft wrote in Myers about a dozen times now. And you can see, even though it clearly comes out on one side of the issue, that there are places where he spots that tension, as Adam just noted, and so it's never going to be real easy to grapple with that, because you really are talking about a tension between two very important constitutional values.
So if I could offer a suggestion on this, I think Dick's right that it's hard to predict how this is going to come out at the Supreme Court level. But it's a very big issue, and let's not limit it to ALJs, okay? Not limited to ALJs. It applies to non-APA agencies even more strongly than it does to ALJs. So what I think there should be is a presidential executive order, either by this president or a new one, that cuts right across that and says that any full-time adjudicatory presiding officer, whether under the APA or not, is protected from removal without cause. If the president does it, it doesn't raise the Article 2 issues. And I think that protecting the independence of our administrative judiciary in and out of the APA really needs to be a high priority, because if the judges can be removed because somebody doesn't like their decisions, we've gravely impaired the quality of administrative justice.
I mean, in terms of predictions, I'm a little more optimistic that the ALJ's for-cause protection will be upheld or preserved, because I put a lot of stock in footnote 10 of the Free Enterprise Fund case, where the Chief Justice took pains to distinguish ALJs from the members of the PCAOB. And, the ALJ program has been upheld many times by the Supreme Court. The Ramspec case in the 50s, Butts versus Economou, South Carolina Ports Authority spoke glowingly of the ALJs. I mean, and of course, many decisions have been, reviewed. ALJ decisions have, by extension, been reviewed by the court. So I would be pretty surprised if, stare decisis principles don't come into play here. And the other thing is, who wants to see ALJ independence be eroded? Certainly not the litigants in these cases. I mean, Dick mentioned the fact that these lawyers will bring any case that will serve their client. Well, how much did the client actually win in Free Enterprise Fund or Lucia? I mean, or some of the other lower court cases like Arthrex. I mean, basically because the for-cause protection got severed by the court in these cases, the winning litigants got nothing out of it. All they got was a group of adjudicators who were upset that they lost their for-cause protection. So, I would think that, it should be a bipartisan among judges and everybody else that that ALJ's for-cause protection should be upheld, and it's certainly distinguishable from the provision in Free Enterprise Fund and also the type of actions that the board took in Free Enterprise Fund.
I wanted to just spend a minute or two on the purely practical side of all this, because what's going on in a lot of these cases, Jeff's certainly right that what the lawyer wants is an outcome for his client. Now the lawyer, I disagree with Jeff on the client doesn't get anything. The client gets another shot. He gets a new hearing. And the next ALJ may have a different perspective. More importantly, by then, the White House may have changed hands. The leadership of the agency may have changed hands. And so there may be a completely different attitude a lot of these cases on remand, the client does wind up with a better deal than the client had the first time. And the lawyer's attitude is, I think it's entirely appropriate ethically, is, well, I don't give a damn about other people's clients in the future. That's somebody else's concern. My duty is to serve the interest of my client. But staying on the practical for a minute, Jeff and I participated in a study that ACAGE conducted in '92, and what we concluded was nobody was very interested when agencies or Congress decided, well, do we make this subject to the APA or do we make it not subject to the APA? Nobody spent much time in that decision-making process on all this highfalutin theory stuff. They looked at two factors that caused them in a high proportion of cases to say, we do not want ALJs. One, it's harder to manage them. These six safeguards just makes it harder to manage. And I know Jeremy in a prior incarnation was at the Social Security Administration. And the Social Security Administration has a hell of a problem trying to manage, 1,600 ALJs. And then the other one is just plain old dollars and cents. They run the numbers and they say, okay, the salary of an ALJ on average is about 1.6 times the salary of a non-ALJ adjudicator. You multiply that by the number of adjudicators we need in the case, and that's a hell of a lot more bucks than I'm willing to spend. And so those two are the factors. They don't sit around and say, well, Article 2 versus due process. They look at those two factors. And I've been working with some of the ALJs and AJs who are trying to get all of this straightened out. And they now recognize that the arguments they need to make to Congress to get something worked out have to include responses to those two big practical concerns.
Well, the ALJ Corps used to have multi-level pay grades. You could restructure it so that there were different pay for, different types of cases or for newer ALJs. But I agree with everything you said, Dick. But it does raise the question of what cases should be handled by administrative law judges. I mean, this Cadillac system was set up in the APA, and now it's not being used very much. If you subtract Social Security and Medicare ALJs, you're left with about 200, if fewer than 200 ALJs, I think, now. And so, and as Michael's pointed out, there are many, many more AJs, administrative judges. So which of the administrative judge cases should be kind of elevated or transformed into ALJ cases? Now, the executive order idea that Michael's come up with, I think, is a good one. We've certainly learned the power of executive orders in the last two administrations. And I raised a question in one of the previous panels about whether the president could decide through executive order that a particular agency program that's using AJs should use ALJs. And the consensus on the panel was he could probably do that, except for some potential problem with an OPM rule. Well, OPM is an executive agency, so the executive order could get rid of that problem too. But for example, if we wanted the immigration judges to be ALJs, couldn't the president say by executive order that the existing IJs are all ALJs and new ones have to be hired through the ALJ process? There are various things that executive order could do, and Michael's got some good ideas there.
Yeah, so I mean, I think that could be done, but as Dick Pierce says, it won't be done because of the cost implications. I mean, it really would be very costly to do it. And it also would seriously inhibit agency head control. For example, ALJs are protected from performance evaluations. They're the only employees of the federal government, I think, that are exempt from performance evaluations. And the non-APA agencies, what I call type B, do have this management tool. So our reform efforts really have to be in the direction of...
That's by statute.
Yeah.
So it could be, that could
right.
be.
So
maybe it's like
could
immigration reform. We need comprehensive ALJ reform.
I think the serious abuses are in the area of outside the APA. We were told in one of the seminars that there was an agency where a new administrative judge was appointed, and it was the law clerk of one of the other existing judges. In other words, there was no adequate selection process. Having an adequate selection process for non-ALJs, for administrative judges, is essential. There needs to be a transparent system of quality control and merit in appointing them. I was also told that the Trademark and Patent Trial and Appeal Board is giving performance bonuses to the patent judges. So that's a real source of potential abuse, because you can be rewarding substantive results that the agency has liked. So this is where there needs to be reform. And if it can't be done through a statute, it should be done through an executive order.
So that raises a great question. We've talked about a number of goals of adjudication, right? Decisional accuracy, interdecisional consistency, efficiency, procedural fairness, dignity values, just a simple chance to be heard, like, Goldberg v. Kelly. The aim of any program, presumably, is to maximize all of these values. But in practice, as Professor Jeremy Shaw so eloquently wrote about in the 70s, they're frequently in tension. How should agencies balance those goals? And what, if any, is the role of Congress in the courts in striking that optimal balance?
Well, it doesn't seem like this is ever going to be much of a priority at the congressional level. There just always are going to be more urgent demands than that, and there isn't much of a constituency for this type of reform. In ACA's recommendation 2016.4, the attention is given to agency procedural regulations. It turns out that in non-APA agencies, there is a big network, a web of procedural protections provided in regulations. Agencies that didn't have to have separation of functions or controls on ex-parte contact actually have adopted them through regulations. So I think that remains a very promising area of protecting the independence of administrative judges, agencies actually doing it themselves. And to the extent that doesn't happen, again, I think it's a really good subject for an executive order that a new president should really look at.
I like the ideas that Michael and Jeff have advanced about executive orders and agency regulations. But one of the other things that we have learned in recent years is those are all very, very fragile. The next president comes into office, I think, and says, I really think that stinks. I'm all for Article 2. I think Article 2 is a hell of a lot more important than this mushy due process stuff. I'm coming out with the opposite in my executive order, and you know that's the end of those safeguards. And similarly, a new agency head can come in and say, "Oh yeah, there's all these safeguards I don't like." And if you look just in recent history, and until a few years ago, immigration judges actually, by regulation, had lots and lots of safeguards. And my friends who are immigration judges say that they weren't enough, but they were a hell of a lot more than what exists now. So a new attorney general can pop in and say, "That's the end of these; they're gone." I also have one other practical problem with using any means of executive order or regulation to make it hard to remove ALJs. Or IJs or administrative judges. I was really very, very strongly in support of that until I started to see the results of the president's executive order in which he gave agencies complete discretion about who they appoint. And as I see the new occupants of these offices in a whole bunch of agencies, I say, yuck, I do not want them to be subject to safeguards against removal. The last thing I want is some person who's never done anything except clerked for an ALJ to have life tenure in a very important, responsible position, or in some other agencies, people who have been chosen because they are believed to be the most biased adjudicators. I don't want them to have life tenure either. So it becomes more and more difficult over time to come up with a solution that produces acceptable results.
But Dick, you mentioned the 92 study that we worked on, and one of the things that we concluded was the system of selection wasn't working at the time. And there were some other problems with the ALJ program, but the main so-called merit selection process wasn't working because agencies didn't want to be limited to the top 3 on the register. And so they would circumvent the register by basically cherry picking ALJs from Social Security because they could hire them laterally. So one of the things the ACA said in its 92 recommendation was the system should be fixed, and then some of these AJs should become ALJs. And we had a list of different types of cases that should be handled by ALJs in the recommendation 92.7. And I think when President Trump issued his executive order, I sort of applauded his intention of making it easier to hire ALJs, but he went too far. He eliminated everything except you have to be a lawyer. In 92, we suggested that the OPM continue to use a sort of a merit selection process, but that we allow agencies to hire anyone who's on the top half of the register, giving them a lot more choices among people who have already been qualified. And so that's I think where I would go in terms of selection. And hopefully maybe all these disparate issues could be combined into a bill that would achieve bipartisan support and support from AJs and ALJs. And
Jeff, you left out the gorilla in the room, the veterans' preference. Under the existing system, which sounds like Dick is trying to bring back, the only people that can be hired are veterans, because they give, and even more disabled veterans, because they receive an enormous preference.
Well, that's only in the competitive.
That's not the way to select judges.
That's only in the competitive civil service. And if I'm not quarreling with President Trump's removing the ALJs from the competitive civil service, I'm saying that, the executive order should be adjusted so that they stay in this new category classification that they're in, but that there's some direction to the agencies or to OPM, that there should be a process that is something similar to what used to exist, but much more open in terms of selecting people off the register.
Jeremy, you have a recommendation on this, right?
We do. Recommendation 2019-2, which at least encourages agencies to adopt specific selection criteria.
Right. encourages them. But I'm saying
Direct them.
executive order, and it wouldn't have to include 5 or 10 veterans preference points. It would be just the usual veterans preference that all lawyers who are being hired can claim.
Well, this is probably a good time to remind people of how important it is, their vote over the next couple in 2 months. We're now concluding that the next president can do all sorts of wonderful things or not so wonderful things, and well,
maybe we can get a question in one of the debates about this.
I want to be very clear. ACUS makes a lot of recommendations, but it doesn't make any recommendations on who to vote for. So maybe we'll go out on this. Earlier, I asked you to make predictions about the future of ALJ independence. Now I'd like you to be time travelers and go back about 75 years. Obviously, next year is the big 75th anniversary of the APA, and there'll be a lot of discussion about, you know, the history behind us and the things yet to come. I'd ask you to put yourselves in the position of the folks who wrote the APA and just explain, how has modern adjudication either lived up to what they expected or fell short of what they expected, or maybe it proved to just raise issues they never expected at all. And if they could have known what was going to come in the decades that followed that law, how might that generation have written the APA differently? Dick, do you have any thoughts on this?
Yeah, I can start on that. I mean, one of the problems there is you first have to figure out what they wanted to accomplish, there's there are 3 different views on what they wanted to accomplish. One view is they actually would like the current situation. They damn well wanted to make sure that agencies had the option of going the loosey-goosey way where the statute didn't apply at all, or going the formal adjudication route. And so at least some of them, if that was their desire, well, they got what they wanted. Another group of people who have looked at the legislative history say, well, no, what they wanted was they wanted virtually all of the adjudications to be governed by the APA, and that's why they in subsequent statutes included hearing, and the Supreme Court got it all wrong in Florida East Coast, saying hearing is ambiguous and doesn't necessarily trigger. Okay. And then there's the folks who say, no, they were trying to get most adjudications under the umbrella of the formal adjudication. Well, if that was their desire, then they blew it. I was quite young at that time, and so I don't know what their intent was.
Well, I think one thing to keep in mind was at the beginning, ALJs were called examiners and then hearing examiners. And they got their name changed because they didn't like being confused with people who tested people's hearing. And what was worse was that the head of the hearing examiner office was called a head examiner. But at any rate, most of these examiners were in economic regulatory agencies. And I think the framers of the APA felt that they were just there to preside, to make some recommendations to the agency head, and then the agency head would decide the case. They didn't envision 1,700 Social Security ALJs and all these, NLRB ALJ. Well, I guess maybe they envisioned them, but the growth of sort of ALJs outside the economic regulatory sphere, and with deregulation, that was reduced even more. So I think they'd be quite surprised by the landscape that they're seeing now.
Michael, before you jump in, let me just add one other wrinkle. I mean, you more than anybody knows that the APA says so very little about informal adjudication, which is so much of what's adjudicated. And it says so much about formal adjudication, for which there's not a whole, not nearly as much of. Does that mean that the framers of the APA just expected the balance to be more on the side of formal adjudication, or were they really just leaving it sort of a free fire zone for agencies to decide for themselves or for individual statutes to decide for individual agencies?
Well, I think the framers gave very little thought to the division between the APA adjudication and non-APA adjudication. And I certainly agree with Jeff that if they realized that 90 or 95% of all of the ALJs are going to be deciding Social Security cases, they would have been appalled. And in fact, it's really very, very arguable that Social Security should actually be under the APA at all, because there's no statute that requires an evidentiary hearing in that case. Very questionable, but that's history. So I think if we could do it all over again, the rulemaking solution is that all federal government rulemaking is covered by the APA unless specifically accepted. And that would have been the right way to go with adjudication as well. So just if I could, this is my hobby horse, I really object to the formal, informal lingo that you guys have been using. Much APA adjudication is informal, Social Security, and adjudication outside the APA can be very formal, much more formal than the APA. So let's not confuse things by calling it formal and informal. Let's try to do something like type A's, B's, and C's. B being evidentiary hearings, which can be quite formal outside the APA, but clearly those should have been under the umbrella of the APA. And if we ever do it all over again, they will be.
I also thought that Professor Emily Bremer's point that she made in one of the panels, that the APA framers thought in terms of stages of adjudication, and that the preliminary stages didn't need a formal hearing because the formal hearing stage would come later. And so that's one of the reasons they didn't put much in about what's now Section 555, because they didn't think there was going to be any need to have a formal hearing twice. And now I don't think that completely describes the landscape of adjudications, but I think it's an interesting point that when we think of adjudications, there are stages of adjudications, and a very preliminary stage, the charging stage, the investigation stage, probable cause stage, there's no hearing.
Great. Well, it looks like we are getting close to the end of our time. On behalf of ACUS, the Gray Center, and the Center for Progressive Reform, I would like to extend my thanks to Professor Asimow, Professor Lubbers, and Professor Pierce for joining us today for this fascinating conclusion to the Symposium on Federal Agency Adjudication. Thank you.
Thanks for having us.
Much appreciated.